for instance, mental capacity and so forth. But my short point is once you're on that jury, you are one of their number until you are actually discharged. But I can deal with it quite briefly, and we sent it over this morning. It goes back to, the Act goes back, I think, to 1892. If you look at, I'm not quite sure what numbering you're adopting, but if you look at, as it were, the opening page of the Act, this Act may be cited as the Jury Act, you'll see it goes back to, it says, 1962 at the top, and indeed, but that's the addition of laws, but you'll see under the heading, the Jury Act, 7th of July, 1898.
Sorry, Mr. Knox, I've got a problem. I can't open the file. Bear with me for a moment.
This is the supplementary Jury Act.
Yes.
The one was sent this morning.
Yes, yes, it would have been sent this morning.
Yes.
I hope it is translatable.
Yeah, I'll try and type it.
Just sent it by email.
It's also on your shared drive.
This is the shared drive that I can't
I've
get
sent
into.
it by email.
It opens on the email, I think.
I've got it on the no. Yes, I've got it on the email. Thank you very much. Sorry.
You'll see it's passed originally in 1898. This is essentially, I suspect, we haven't had time to do a full research. Essentially, in the Caribbean countries, there was often codification of the common law in the 19th century, and we rather suspect this goes back to a sort of codification translated to Jamaica. But you'll see, first of all, Section 2, qualification of jurors, and you'll see there's a requirement in Section 2.1 for any person of certain age and so forth to be qualified and liable to serve on juries. You'll see certain exceptions, one of which is in 2B, sub 2.2b, cannot speak, read and write English. And others, D, for instance, you've been convicted of treason or another serious offence, then you're not qualified. And then subsection 5, save as provided by or pursuant to this section, and subject to section 18, no person qualified to serve shall be exempt from jury service. And then section 6, no person whose name is on the jury list, I'll come to that in a moment, as a juror shall be entitled to be excused from attendance at court on the ground of any disqualification or exemption other than illness not claimed by him at or before the final settlement of the list. But a judge, registrar of the Supreme Court and so forth may excuse any person if satisfied that the person is disqualified or entitled to exemption, hardship in the case of employment, or such person for the reasons which appear sufficient to the judge and so forth should be excused. And that's why I say this is essentially a public duty. Then section 7, you have the provision as to how jury lists are made up. I don't propose to read that out, but there's a provision for making up of jury lists. And section 8 gives further details as to how the jury list is to be drawn up, essentially by justices. And then section 10, it shall be lawful for the justices at such sessions to strike out of such lists the names of all persons shown to their satisfaction to be not qualified or not liable to serve on juries, or to be dead, or disabled by mental capacity, deafness, blindness, or other permanent infirmity. So this is the way, as it were, you're removed from a list. And then B, to add to such lists the names of any other person, and then C, to correct errors. And then moving over to section 13, where the list has been settled, the justices shall certify that the list is to the best of their knowledge a true and proper list, and so forth. And that is the list which is to be used from which jurors are subsequently selected. One then goes to, I think, provisions we already have, section 31, on trials on indictment for treason or murder, committed in certain circumstances, and that's essentially capital murder. 12 jurors shall form the array on trials on indictment before the circuit court other than for an offence in 1, 7 shall form the array. And then 3, forgive me.
Can I just ask, is ours a murder falling within either of those two categories.
No, I don't think it is, because it's, I think, just dropping down, it is in, whether it's 44, section 44, I have a feeling.
Yes, well, in fact, it's with a view to section 44 that I was asking the question.
Yes, yes. We're in section 44.
Would we have been in 31 1B but for the discharge of one juror? Or is it not a murder within?
I have a feeling, I can double check this. In Jamaica, they've got a capital, they essentially have capital murder,
Yes.
for killing a policeman in the execution of his duty. And for that, you need 12. That's
Oh,
what
you
I
can't
understand.
go
this
lo-
to
oh,
say.
I see.
You can't go below 12 for that. But we're not in that category. So 31, 12 jurors shall form the array. And then subsection 3, where in the course of a criminal trial any member of the jury dies or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as, my lords, you can imagine, I emphasize this, the number of its members is not reduced by more than one, be considered as remaining properly constituted for all the purposes of the trial. And the trial shall proceed and a verdict may be given accordingly. And then subsection 4, where one juror has died or been discharged, the verdict of 11 jurors in a trial for treason or murder referred to in 1B, or of 6 jurors otherwise, shall be deemed to be a unanimous verdict. So that does
And
provide-
so ours would be within the ambit of the provision about 6 jurors.
I don't think we're down to 6 jurors, no. My lord,
No, well, we're not in the. You just told us ours isn't a trial for treason or murder referred to in subsection 1B.
my lord, if I can just double check, that's my understanding. Certainly my understanding is that it may be, if I can double check this, it may be we are in fact in 31, so that you can go down to 11. That certainly seems to be the assumption on which everyone proceeded.
Well, I don't know if they did, because when you get to 44,
Yes.
I think the implication of 44 is that you need a unanimous verdict to convict of a murder falling within the categories described
Yes.
in 31 1B.
My lord, can I just take instructions from those behind me, because that explains it. What we're looking at here is, if you look at section 31, it's an amendment made in 2015.
Yep.
That is why there's confusion. I do apologize. But the proper 2010 Juries Act is already in the bundle. In other words, what I produced today in this section is a 2015 amendment, which I think, well,
Right.
which would post-date the trial.
Can you show us in the 2010 version?
Yes, that would be, I think, I think I'm right in saying volume 1. I hope I'm right in saying volume 1 of the
Same amended.
Yeah, we've got section 31, but we don't have section 44. But it's
also got the 2015 amendment.
it's the version we've got in bundle number 11 on is again the 2015 as amended in 2015. That's page 6803.
My lord, I do apologise.
I appreciate you don't bear sole responsibility for this, Mr. Knox, by any means, but it's quite important that we actually have the legislation that was enforced at the time of the trial.
My lord, absolutely.
Yeah.
My Lord, can I say one of the difficulties? This wasn't a point, of course, that was raised in the appellant's grounds and so forth. So it has been a bit of a rush, and I do apologise. It does look as if
we don't need to be rushed. We can adjourn for some minutes if that's going to give you time to get hold of a copy of the correct version of the Jury Act.
as in force at that time. It's not always that easy from my experience. One has to dig back a bit. But can I just say this, certainly for the time being, the point I'm making, I'm assuming, as everyone has assumed, that a jury of 11 was a sufficient number, but it couldn't go below 11. That appears to have been common ground throughout the trial, and indeed in the Court of Appeal, as I understand it. So that's the premise. You can't go below 11. The point I'm on, in one sense, is not whether or not you can go below 11, but what is the nature of a jury? And the nature of a jury, in my submission, is simply there are 11 members on it. And if there are 11 members on it, you've got a quorum. Even if, for some reason, one or other of the jurors is not is acting improperly, or there's reasons to suppose he's acting improperly. As long as he's on the jury, he is one of their number. And it's only when he's discharged that the jury number is reduced. That is the point I'm seeking to make, my lords. And I do accept, my lords, that obviously it would be important to get the right version for you, my lords. If we could, I'm not sure we could do it within a matter of minutes, just from experience, but if we could do it as soon as practicable, and get over to you the relevant section with, if appropriate, a very short note about what it comes to, that might be a better way of dealing with it. But for the moment, my lords, I'm just making the point, there was a quorum. And the reason I say that is because jury service is a public duty. You can't just get out of it. And once you are in the charge, if I can put it this way, of the jury, it's the jury who has to deal with you until the judge says, until the judge, quote, discharges that particular juror.
31.
My lords, I've just received a note saying the Deputy DPP has sent the 2010 Act. I went and received it myself, but my lord, perhaps I could just come back to that in a moment rather than take time trying to find it myself. My lords, yesterday one of the questions was put, well, what about mental illness? Now, one can see that if someone becomes mentally incapable in the course of the trial, let us say, on day 7, he is simply incapable. Well, my lords, in my submission, he is still strictly on the jury unless and until he is removed. But in circumstances like that, the judge in my submission would have no choice because that juror would be incapable, simply incapable of performing his oath. And there's a difference in my submission between the juror being incapable of performing his oath and the juror who is capable of performing it, but who is, for one reason or another, bent on not doing so. And in the latter case, I submit, he still counts, and the judge is still entitled in principle to say, I'm going to carry on and I'm not going to release you from your oath. So that's the first point I wanted to make on the quorum. The other point I was asked yesterday, could a court review a decision made by the jury after it has made it to find out whether or not it was in fact, there was in fact, let us say, a crooked juror on it, with a view then to that conviction being set aside? And my lords, my lady, the answer to that is yes, and that's exactly, it was the issue in the case called Merzer, which is in the bundles at 7490. And that was a case where after the event, one of the jurors, the disgruntled juror who'd wanted an acquittal, wrote, I think, to the court or to the judge saying, I'm very unhappy about this because I think the other jurors were racially motivated to produce a conviction. And the matter went up to the Supreme Court. And of course, one question was whether, given the Contempt of Court Act, 1981 in the UK, the court could actually investigate that allegation. They held that they could on the footing that the Contempt of Court Act wasn't intended to prevent the court from making such inquiries with a view to an appeal. The common law position was, they held by implication, that of course the court can, with a view to an appeal, make such an investigation if necessary. And on the facts of the case, the Supreme Court held, I think it was the House of Lords held, there was no need, there was no requirement to look into the point. But when we pick the point up, it's at 7490 at paras 9 to 10. That's where the case starts at 7504. And this is in the speech of Lord Steyne, 7504. Undoubtedly, there must be a general rule. Deliberations of the jury must remain secret, and they refer to Gregory, the ECHR case, which accepted that. And then, moreover, there's a strong rebuttable presumption that the jury was impartial, and that is how the matter is dealt with there. They went on at the end, or rather, Lord Steyne giving, I think, the speech with which others agreed, at para 32.
We must be a little bit careful with Lord Steyne because he dissented.
I have a feeling he may have dissented in the result. I'm not sure if he was dissenting in the...
Yeah, look, I haven't read this for years, so I can't recollect, but I'm just saying we need to be a little bit cautious.
Yes. I'm not sure he dissented on this point. But if one looks at the head note, he does, he is, as it were, agreeing that the court can look at the position after the event. And we'll get to that from the head note, but I was also taking you to where Lord Steyne.
Where were we going after page 7504?
I was going to go to 7512 at 32, where Lord Steyne says, well, on the facts, he wasn't satisfied that the complaining juror after the event was giving an entirely accurate account.
Which is paragraph?
32.
Thank you.
But as I understand it, you're saying this case would fall within what's called the only exception, paragraph 11.
Yes.
Yeah.
So the secrecy rule is the prevailing rule, but there can be exceptions. And that's the main holding. I'm just looking at 7490. So, my lord, that's what I say. So it is in theory possible. It would in theory be possible for a juror after the event who's kept, or for it to be discovered after the event, that a juror has been bribed, he's kept it to himself, and for the court then to investigate. But in my submission, in those circumstances, the court would still say, even though the juror had been bribed, let us say, the jury was quarrelled.
Is the ratio of Mirza at paragraph 94 in Lord Hope's speech, on page 7527, paragraph 94 onwards? which makes clear there is a prohibition. It's only where, in effect, some extraneous occurrence has occurred that means effectively the jury didn't deliberate. They used a Ouija board or something of that kind.
94, 96, yes.
Yeah.
95. There's no, of course, there's no doubt about the general rule. My lord, that's what I have to say about the quorum point. Was the jury quorum? My answer is yes. The next question is, was the judge bound to discharge the jury in any event? Because the risk of prejudice or bias was irremediable. Should he have said at that point, when the complaint is made, should he have simply said, well, we can't carry on, full stop, because of the risk of prejudice to the defendant. So my submission, no. First, there's the point I made yesterday. It cannot be the case that an accused can engineer the automatic end of a trial by his own misbehavior, tampering with the jury. And likewise, I submit that cannot be the case in the event of a juror who, let us say, he hasn't been contacted by the defendant, but for whatever reason, he is acting in the interests of the accused and offering bribes. It cannot be the case that a trial can be brought to an end so automatically in those circumstances. And in my submission, were there to be such a rule, this is a common law matter, that would bring the system, the whole legal system and the jury system into disrepute and make the administration of a jury trial almost unworkable. Second, on the facts.
Why do you say that? Because in normal circumstances, if this came to light, that particular juror would be discharged.
I agree with that, normally.
So the whole system wouldn't come to a halt.
In circumstances such as this, I agree with that. Because you could discharge a juror, but in circumstances such as this, it would bring automatic. If my learned friend's right, there's an automatic. It just comes to an end, full stop. I submit that cannot be right. There is still a power in the court, as long as a fair trial can be ensured. There's still a power in the court to allow the trial to go ahead. And in my submission, the next question then is, well, did the judge exercise, or can it be said the judge exercised his discretion wrongly and perversely in allowing the trial to go ahead? That is the correct question, focusing on the position as it was before the trial judge when the complaint. And in my submission, the trial judge, it'd be wrong to interfere with the trial judge's exercise of discretion for the following reasons. First, as things stood, it was a mere allegation, no doubt one which appeared to be supported by strong evidence, but it would not be practicable at that point to carry out an investigation of the corrupt juror himself. That couldn't seriously have been done. And what is more, my lord, I might add, although he was found guilty of attempting to pervert the course of justice, he did in fact plead not guilty. One just wonders, well, what in real life? What benefit would that have done? How could the judge have taken matters further? He had it on the word of the forewoman that she had told the jurors that they weren't to take any notice of this, and in my submission, that was good enough. What was to be gained by the judge asking each and every juror what their position was? Secondly, in my submission, the judge was entitled to take into account the view expressed by the forewoman that none of the 10 jurors had accepted the bribe. That's an important point. He's entitled to take that into account and say that, well, that sounds true to me, and that she, the forewoman, had told the others that they must abide by their oath. It's obvious that the judge was impressed by the forewoman, and he will have seen her, and he will have to form a judgment as to whether she's a trustworthy person. And he's entitled, in my submission, to take that into account. Third, he was entitled to take into account, A, his own directions so far, and I'll come to those in a moment, B, his assessment of the jurors over the 56 days of trial so far, especially this, my lord, it is evident they had acted on his repeated warnings not to talk to anyone, despite the obvious temptation of doing so in such a high-profile trial. And C, he was entitled to take into account that he could give a further direction that could be given to remedy any prejudice to the accused. Now, I'll come to that direction, if I may, in a moment, but just before he goes back into court, he's entitled to say to himself, it is proper for me to carry on with this trial because I can ensure that a fair trial will happen, bearing in mind everything that's happened in the case. Thirdly, I emphasize this point. The Court of Appeal, who have a good knowledge of the local circumstances, upheld the way the judge dealt with that. And that you see at E5869, paragraphs E5869, my lord, yes. 5869, paragraphs 237 to 238. And then also 240 to 241. Two three seven to 238, 240 to 241.
I mean, the paragraph, the second sentence on page 5869,
Yes.
that approach, on the face of it, looks somewhat problematic, I would suggest. That we don't want to investigate much further because the likelihood is we're going to have to discharge the jury.
Well, my lord, one has to see that in context. He's saying, with nothing has been gained and a great deal that we've lost, the possibility of having to discharge by questioning the accused juror. So he's not just saying, the Court of Appeal saying what was to be gained by questioning the accused juror. And in my submission, that was a perfectly proper approach. I mean, one does ask, what was to be gained by?
But it's an acknowledgement that that juror was not going to abide by his oath,
Well,
isn't it?
oath. Well, it's an acknowledgement that he may well not abide by his oath. That is right. I cannot deny that there was obviously a risk, bearing in mind
Or more than a risk. It was
a likelihood, maybe. So far as one could tell, one only has an allegation. But I come back to the point I made yesterday.
Well, if it was just a risk, then he would have investigated and impressed upon the juror the importance of not being affected by extraneous
yes.
considerations.
I can see that. But even if one allows that, you have my submission yesterday. If the risk is just that one, or probability that just that one juror is not going to perform his duty, that in my submission is not a reason for discharging the entire jury if the prosecution, who are affected by that bias, says carry on anyway. And that you might say is a pragmatic point, but in my submission, that is a perfectly proper approach for the court to take. If it is, I mean, it wouldn't be right the other way around. If there was a juror who's biased against the defence, that might all be very different indeed. But here we are talking about the state who's bringing the charge in the public interest, who knows there is a problem with one juror. But one juror is bent against the prosecution, come what may. Let us assume.
But the real problem which we're facing isn't it that there was a risk that the whole of the rest of the jury were biased against the defence?
My lord, I accept that's a different risk, if I may, for the moment. That is a different risk. But just as far as questioning the individual bad juror, my lord, and that was the point which this particular paragraph is on, I submit that there was nothing to be gained. There was indeed. What's he going to do? He's just going to deny it, probably.
Yes, but it is really the point I think that Lord Burrows was making, that if you read on, saying a great deal would have been lost by questioning the accused juror. And what would have been lost would have been the trial, because if the accused juror had admitted the conduct alleged, then not only he but the entire jury would have had to be discharged.
Well, my lords, I submit he wouldn't necessarily have to discharge the jury, even if, let us say, the individual juror had said, "Oh, I own up. I did try to bribe them." My lords, it all goes back to the single point. There's a different point that Lord Briggs makes, which is about the inspection of the rest of the jury, but it's just this one point. Supposing the judge is entirely satisfied that 10 jurors can perform their duty properly. I'm sure they're able to do it, but he knows that one is very unlikely to do so. Supposing that is the position, the question is, as a matter of law, must he discharge the jury? That is the question. And if the answer to that is yes, he must, then I accept I'm in difficulties. If the answer is no, he doesn't have to, if the prosecution is content to take the risk that this one juror is just going to vote against the prosecution, come or may, in my submission, he's entitled to do that.
I think the answer that would normally be given is you must discharge that juror.
If of course, I agree with that. In normal circumstances.
So if we assume that the legal position is you must discharge that juror, what is then your submission?
Well, in my submission, if you absolutely must, in all circumstances, even in a case such as this, where you've got right to the end of the trial, you can have a 10-1 verdict, and so forth. If you must, then my lords, I accept. Then what has happened is that the verdict that was given by 10 people who were entitled to be on the board, panel, and one person who wasn't. And then the consequence of that would be, I suppose, that you do not have a quorate verdict.
The implication of your submission seems to be that in a criminal trial, and you could hardly have a more serious trial than this, where you have 5 people accused of murder. Clearly, there's a public interest in a true verdict being returned. The implication of what you're saying seems to be that the judge really has no responsibility in that regard. He's entitled, if the prosecution are willing to run the risk of the jury being nobbled by the corrupt member of the jury, that's a matter for them, and he can go along with that.
My lords, he has to be satisfied that the other 10 won't be nobbled, or it's very unlikely they'll be nobbled. I'd accept that. But if his thinking is, and I submit it was likely to have been this, I've got one bad juror here, I've got good reason to suppose the other 10 will behave properly. That means there will be, the jury will be quorate at 11. In my submission, he is entitled, he is not bound to say, I've got to stop the trial now. He has a power to allow the trial to go ahead. That is, and my lords, I accept that is the kernel of my submission. It has to be one which he exercises not entirely unreasonably in all the circumstances of the case. That is why I'm making the submissions I have been.
If it were the case that the same rules applied in Jamaica as apply in England and Wales, that is, you could have had a jury of 10, what would you then say?
My lord, I think I'd be bound to accept that the judge would have said, let's go down to 10. He probably would, in those circumstances, have said, balance.
So the problem that you're faced is a system that doesn't allow a jury of 10.
That's exactly the problem. The whole problem.
An unfair trial, it might be put against you, is allowed because the rules don't allow a jury to go around to 10. Is that right?
No, I'm not saying that. I'm far from saying that. As long as the trial is fair, overall, I haven't come to my point about the fairness of the trial, but as long as the judge is satisfied that a fair verdict can be returned, even though one juror appears to be bent on assisting the defence, the judge can say, the lesser of two evils is that the trial goes ahead, the administration of justice is served by the trial going ahead, and there is no common law rule that requires me to stop the trial.
The corrupt juror might be critical, his vote might be critical to whether there was majority or not.
It might be, But in those circumstances, that is a risk that the prosecution takes.
Well, that's the point. You see, that's the point I'm jibbing at, really.
Yes.
The idea that responsibility for the administration of justice in the public interest is the responsibility of the prosecutor and can effectively be waived, if you like, by the prosecutor, rather than being the responsibility of the court.
Yes, I do accept that, but my lord, it is still the responsibility of the court. If the court is satisfied,
But we see the problem. If you're presiding in a criminal trial where a majority verdict can be returned, and you know that one of the members of the jury, or you have good reason to suspect that one of the members of the jury may be corrupt. For all you know, the way he votes in the jury room could be critical to the verdict that's returned, and could result in a wrongful acquittal, for example.
my lord, again, I come back to my point. That the judge is entitled to weigh up all the different evils. I mean, the real problem is that the judge was caught between two evil solutions.
Yes. I've got the greatest sympathy for the judge. And I mean, in this country, we would think twice about rerunning a 67-day trial. But in a country like Jamaica, the expense involved in this, apart from anything else, is enormous.
But my lord, my submission is this: as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably, rationally in making these decisions, and as long as they are satisfied that overall there can be, not necessarily that there will be, but there can be a fair verdict. If there can be, then in my submission, the lesser of two evils is to go ahead and get that fair verdict, rather than simply say, trial off, no verdict, which in real life may well mean no trial whatsoever. And that is why I say one must look. It's not just a matter of sympathy for the judge, it's what is the responsible, forgive my putting it this way, the responsible response to this very, very difficult situation. Which is the lesser of two evils? And my submission is the lesser is to go ahead in the hope that there can be a fair verdict. You may well land up with an unfair acquittal. That is one risk you take. But it is better to take the chance of getting a fair verdict than to abandon that altogether.
That fair verdict would be reached in circumstances where the allegedly corrupt juror would not only have a vote, but he'd have the opportunity to influence the other members of the jury.
Well, he might still seek to influence the other members of the jury, but he wouldn't. Sorry?
In deliberation.
In deliberation. He can still say what he likes in deliberation. He can still draw attention to a good point, let us say. That can still happen. He's not prevented from doing so. He may well be able to persuade one of the other jurors, not by offering money.
Well, by offering money.
No.
But he may.
No, he may be able to persuade one of the other jurors in deliberation. Look, forget about my bribe. These people are innocent because of point X. He's still entitled to do that.
Well, he's entitled to do that, but he's not entitled to persuade them by offering them bribes.
Certainly
That is an ongoing risk.
That is, my lady, I accept that is an ongoing risk.
Yeah.
That must be right, is a risk. He will try again.
Yeah.
I mean, you might think it's a bit unlikely if the matter has been reported to the judge, actually, but there's a possible risk. Let us say there's a possible risk. My lady, even in those circumstances, if that is a risk which the prosecution is prepared to take in order to achieve a verdict, that is the lesser of two evils. And if both the judge and the prosecution think that is a proper way of proceeding, they can. That is my fundamental point. And one of the problems with jury trials is one is trying to create a system of perfection. In one sense, of course, this is not perfect. No one would begin to say it's perfect. But is it, in fact, the pragmatic way forward, which did, in the event, secure a fair verdict? That is not.
But the defendant's counsel didn't accede to this way of proceeding. That they continued to raise on the face of it, it looks as if they were objecting.
They did. There's no doubt about that. But they were objecting for different, they weren't objecting on the quorum point, but they were objecting because of the way it's put, I think, by one of them is the overcompensation point. I'm concerned about it. And that's a fair point.
Yeah.
I'm not saying it's a bad point, but in my submission, it's not a conclusive point. Judge is entitled to say, well, I'm still prepared to put this matter to the jury because of the various points I'm going to come to later, because the strength of the case, I've been assured that I will give another direction. I have already given directions about not being persuaded by extraneous matters. The judge in my submission, and this is in a sense the heart of the case, was he bound to stop it? My answer is no, he was not bound to stop it, for the reasons I've given. And I do submit, I take my Lord's point about the Court of Appeal's judgment, but I do submit this is important to bear in mind what the Court of Appeal had to say about this matter. They have familiarity with how juries work, how the system works, and it's their primary responsibility to ensure the criminal system works properly. You are operating as a second review court. This is a point to be made again and again. And I do submit great respect should be given to the Court of Appeal's assessment on this point.
Well, it will be.
But so, my Lord, you have my point on that. So I say there was no error of law in what the judge did. That's what it boils down to. He acted within his discretion. It was not an unreasonable decision to make, given the extremely difficult circumstance in which he found himself, and the possibility there could still be a fair verdict. That's the point. My Lord, can I just turn to the judge's directions? But it's important, it ties in with the previous point. I've already given you references to some directions before. Can I also ask you to go, please, to E4723, the 4, which is what he says to the jury right at the beginning, which is a resounding direction in my submission. E4723. 4723.
4273 or
4723.
This is right at the start, is it?
Yes, right at the start.
Start of his summing up.
Start of his summing up, yes. And it continues to 4724.
Now, this was, at this stage, by the judge in ignorance of modelling.
Yes. And I don't propose to read that. If you could just read those 2 pages, continuing to the top of 4725. And I should actually ask you to continue to near the foot of 4725, actually. If I may. Now, if I can answer Lord Barrow's point he put to me yesterday about more pointed summings up in other cases. If this had followed the incident about the bribing juror, one would say it covers the points. Ignore all prejudice. In particular, each of you, right at the beginning, each of you took an oath or affirmation. You will recall that. This is of great significance. I want you to hold to that. The oath is of great significance, not to be treated lightly. The essence of what you swore to do or affirmed is that you would decide the case based on the evidence, and then repeatedly he goes on later. He says, I've been boring you all the time about my constant reminders, and they're all over the place. I tell you again, because it was of tremendous importance and remains such. Then 4725, I implore you because of the oath you took, serious and responsible function that you have, you cannot bring external considerations. My submission is this: he doesn't repeat this after the incident, but he said it right at the beginning. And in my submission, one has to act on the premise that the jurors haven't forgotten all about this, especially because it's something he's been, if I may put it colloquially, he's been banging on about all the time, the importance of the oath and the seriousness of the task they're employed on.
Can you remind me how long the summing up lasted?
I think it begins on the 6th of March. You can see that at 4722.
Ends on the 13th.
Yes, I think there are breaks. I have a feeling it may have been 3 days altogether, but I will be corrected if it's 4 days.
Thank you.
I think there may have been, but anyway, we know the gap is ultimately 6th of March to the 13th,
I think so.
which is perhaps the more important point.
Yeah.
But in my submission, they won't have forgotten all this. Can I also, while I'm on this point, at 4738, a little bit further on, is the point about prejudice. And this, 4738 to 4741, he goes on about prejudice. Ignore all prejudice. Just look at the evidence. Don't speculate. And it goes on to 4741. In 4741, halfway down the page. If I can just ask you again to read that yourselves. In particular, the first half of 4741. Again, I implore you not to allow feelings of sympathy or prejudice to influence you, cause you to ground your verdict. There's no room for a verdict which has its genesis in sympathy or prejudice. Your verdict must be arrived at on the basis of the evidence and on that basis alone. All this is coming quite early on in the summing up, but it's absolutely emphatic. And just while I'm on the summing up, 4769 is where the judge gives his direction, or the first of his directions, 4769 to 4770, to keep separate. That is to say, consider each of these cases separate. It's an important direction in the context of this type of case. Now, in my submission, taken in the round, these directions were good enough to ensure that the 10 jurors at least who returned the verdict of guilty did so uninfluenced by the offer, or by the misconduct, rather, of the bribing juror. They would not, in my submission, in the light of this, have said, or been subconsciously influenced against them. These couldn't be firmer. That leads me to my fourth point. Was there, looking at the case as a whole, a real risk that the trial was unfair? It's a slightly different question, but it's a global question. I say no. First, I say...
Just before you go there,
Yes, of course.
could I trouble you just to take us to what was said by the judge immediately after the hearing in chambers? You took us to it yesterday, just in terms of page reference.
Forgive me, my lord.
5149.
I'm very grateful.
Yes.
Now,
5149.
514.
5149 lines 4 to 13.
Yes, thank you.
thank you.
This was after the
Immediately after.
Immediately
yes,
after the matter had been raised with the judge.
Yeah. So the jury come back in, so to speak, after the half hour when they've been kept waiting. And this is the first thing the judge says.
Sure.
And that's why we say it's obvious to the jury what he's referring to, because they will know what has happened in the previous half hour.
Are you suggesting that's a targeted direction? It might be said against you. He's just repeating what he said right at the start of the trial. He's had a specific allegation made, and all he's done is to repeat what he said to the jury at the start of the trial.
Well, without adding quite a bit of the stuff he did say at the start of the trial, summing up. That is true. My lord, I fully accept it is not targeted. The question is overall, the overall question is, did the jury, is there a real risk the jury was influenced against the appellants? I submit no. They've got the message from the judge loud and clear all the way through.
Do we see anything in either the judge's appraisal of the problem or in the Court of Appeal's appraisal of the problem of a real weighing of the risk of what I think counsel for the defendants at the time called overcompensation, i.e. a risk that because there'd been a widespread attempt to bribe the jury, then the defendants must be guilty?
My lords, I think it's fair to say there is no, well, the judge himself, obviously, he doesn't, because
He's obviously heard the
split decision. Yes, no, he doesn't. No. He just goes ahead. It's a fairly short, the trouble is it's all dealt with very quickly. It's a
The Court
short
of Appeal don't seem to address their minds to that issue.
Not quite clear to what extent that was.
You've shown us at any rate.
One of the problems is in the Court of Appeal, as far as one can tell, that doesn't really appear to be the main thrust of the appeal. The thrust of the appeal was more investigation should be made by the judge. The bias point, it was there, but it wasn't, so to speak, centre stage. That's my understanding. And so that, no doubt, is why the matter doesn't receive the attention which now it's been subjected to. But my lord, the next question is, if I may, was there a real risk that the trial was unfair? I submit that is the ultimate question. That is to say, unfair by reason of subconscious prejudice, conscious prejudice against the accused because of the bribes that have been offered, apparently in their interest. I say there is no real risk that the 10 jurors who voted to convict were influenced to do so by their knowledge that bribes have been offered by the miscreant juror. And first of all, can I just make this point? I submit it as more accurate to describe the question as one of prejudice than as one of bias. The reason I say that is this. Bias generally, in general language, arises as a result of an internal disposition which affects a person's whole way of thinking about a case or about a matter. And this, in my submission, is a heightened, and therefore there's a heightened risk that a juror won't comply with his oath. Supposing I'm an absolute outgoing, out-and-out racist, I believe all black people are useless or bad. You're never going to get rid of that. The problem is you're very likely, it's just me, it's part of me. Well, let us say I'm a Chelsea fan and I'm a referee in a Chelsea game. I'm just going to give all those split decisions to Chelsea and so forth. It's just in me. I can't help it. That's, in my submission, bias, which is irremediable. But there's, at the other end of the spectrum, there's prejudice, which arises as a result of, or potential prejudice, which arises in the mind of a neutral person, or neutral jurors, which comes about as a result of an external event, such as here. Or it could be, let's say in the course of a trial, knowledge of bad character comes out. It's that that's the real analogy we have in this case. The jurors have found out something which could weigh against which could cause them to weigh or take things into account against the accused and make him think that he is guilty when otherwise they would not have come to that conclusion. And in my submission, it's that type of case we're dealing with. Was what happened something which is likely, or there's a risk that it caused them to come to a conclusion they would not otherwise have come?
Does it make a difference whether it's bias or prejudice?
It may not, but the reason
what difference it does make at the moment.
But there are some types of prejudice which are more deep, if I can put it this way, insidious. and that would be a racial bias, than, for instance, I'm a neutral person and I've come to find out something in the course of a trial, and it will be easier in my submission for me to forget. And the court can more easily assume that the jury will comply with their oath.
So do we come back to Lord Justice Bingham's, as he then was, test in Putnam, where
Yes.
there's a real risk that, not on this occasion a single juror, but all of the jurors, or one of them, might, as a result of the approach, consciously or unconsciously, have become prejudiced
Yes.
for or against
Yes.
one or more of the defendants?
Yes, that, I accept that as the test. And that's, in fact, where it's put those prejudice rather than bias. My Lords, I accept that is the test. But, as against that, you have to start from the premise that jurors, you can trust jurors not to be prejudiced and to follow their oath. And I've given you the reference in Bonnet. I won't take you through it now because I'm conscious of time, but also at this point, a similar point arose in the case of Morrison, which you can see at E7560, in particular, in paragraph 19. We refer to this in our case, and then 7565, paragraphs 40 to 41, 42, and 44 to 45.
Sorry,
7565, 40, I think, putting it more simply, 40 to 45. And that was a case where, again, the Court of Appeal said, well, you must trust the jury to perform their oath in accordance with their duty. It's a fundamental tenet. Now,
Mr. Knox, I should let you know that we've now received the correct version of the Jury Act, and the version of Section 31 that was enforced then is much simpler, and I think it all makes sense.
I'm sorry it didn't make sense.
Well, it's rather easier to make sense of it.
But I'm grateful, my Lord. I haven't yet seen it, but my Lord, I'm conscious of the time. Can I just I move on to my next point? The first point I'm making is you can trust the jurors. This was a question of prejudice, external prejudice. You can trust the jurors to obey their oath. That's my first point. The second point is this. For the purpose of deciding whether the jurors have complied with their oath, you look at the case as a whole, and especially two things. The overall strength of the case, because that goes to whether they would take any notice at all of the offers of the bribe, and secondly, the actual verdicts they came up with. If I can deal with the second point first, the verdicts. As I mentioned, Shane Williams was acquitted. The evidence against him was less strong. It was simply that he was identified by Chow as one of the men in a video talking about, or appearing to talk about, a killing. The case in which this point is made that you can take into account, or it's a point that matters, is the case of Sander, which is an ECHR case at 7965. I won't take you to it, but it's in the dissenting judgment of Sir Nicholas Bratzer. I think it was 4-3, but he makes the point that the Court of Appeal in England had found it a significant point that there were two Asians, one of whom was acquitted, one of whom was convicted. And that was a significant point in showing that the alleged racial bias didn't actually make much difference. It was unlikely to have made any difference to the jury's thinking. And likewise, I say, by parallel reasoning, here too, the bias, if you've expected the bias at least to be operative, or you would have expected Shane Williams to be convicted as well, but he wasn't. As to the strength of the case, if I can summarize it briefly, just taking one or two passages. Prosecution evidence fell into 5 categories. First, there was Chow's evidence. That is summarized in the Court of Appeal's judgment at 5778, paragraph 9, to 5779, paragraph 12. In short, he goes along with the deceased. He's taken along with the deceased in the car with Campbell at the front, driven along, and then he says, because they're being summoned because the guns have gone missing, and then he witnesses the killing by the 4 appellants at the relevant premises, those premises being owned by Mr. Palmer. After that, he returns and he takes Mr. Palmer to hospital. After that, he is offered, they try to get him, Chow, to leave the country along with them. a few days after. That's the thrust of his evidence. Now, that was obviously evidence subject to a lot of challenge, but the real point about it is it was supported by all the technical evidence. It was supported by the technical evidence, the phone calls and so forth. Well, that was one category. The second category was the deceased's girlfriend's evidence, to the effect that the deceased was never seen after the 16th of August 2011, the inference being he was obviously killed on that day, as Child said. The third category was the evidence of the police investigations after the killing, and in particular, the entire interior of the house where the killing took place was burnt on the 27th of August, about 2 weeks later. There was a foul odour there on the 29th of August, query what was going on, and then by the 30th of September, the entire rear of the house had been demolished. And that is, you get that at the Court of Appeals judgment 5780, paras 14 to 5781, 17. And the appellants were arrested on the 30th of September 2011, and that's 5781, 18. And the point about the burning of the houses is that this was Palmer's house, and there was no report of any damage being done to the house at all by Palmer, and that was a point that was made to the jury. How come, if he owns the house and it's been damaged or burnt down, or burnt at least, how come he makes no report of it at all? The next category of evidence was Exhibit 14C. That consisted of voice and text messages from Palmer, and they are summarized at E5803 to 5807, and they are also summarized in the SFI at E6135, para 10 to 6136, para 13. If I can just ask you briefly to look at the Court of Appeals summary of that evidence, because it just couldn't be clearer. E5803. The passage describing Exhibit 14C begins at paragraph 69, and then paragraph 70 describes or summarizes the effect of the voice notes. In the original, they're quite difficult to follow because they're all in patois. But you can see if you read 70, paragraph 70 at 5803, on to, if I may ask you just to read yourselves to 5806, the end of 5806, you can see the nature of this evidence. And in particular, you will have seen in passing 5805, paragraph 73. This is Palmer's text a few days after the event. Between me and you, the recipient's not identified. We chop up de boy lizard, that's the deceased's nickname. Fine, and dashing we enough. As long as you live, dem can never find him. Oh, couldn't be clearer. But the whole picture couldn't be clearer. And then we have also from JS2, I'm just going to give you the references. We have the texts between the deceased and his girlfriend, in particular on the 16th of August, 2011. They are summarized at E4788 to 4791. And you can also see a short summary at in our written case, is 6227.
Can you just give those references again?
Of course.
Yeah.
4788
Yes, thank you.
4791 And in our case, they're summarized again at 6227, paras 40 to 41. But those texts show without a shadow of doubt that the deceased was on his way to be executed, and he suddenly realized what was going to happen to him. There can't be any doubt about that. There are some texts also from Palmer. They were of no significance, but there were texts from Sean Campbell, which to an extent were incriminating, which suggested that on the day of the killing, but before the killing, Campbell said, who tifit ago dead, that's say whoever stole it is a dead man, and then after the event. But the references, you can see those texts at 4989, lines 1 to 14, and 4990, 13 to 4991. So they're plainly incriminating. Now, the defense cases, and it's important to understand what the defense cases were, they all just gave unsworn statements. Palmer's case was simply that he had never met Lizard at the premises on the day in question. And my lords, that is at 4341. I should emphasize this. The SFI says that Palmer says he wasn't at the premises. That wasn't actually what he said. He said, I didn't meet Palmer. I never met Lizard at the premises. Rather different. So he doesn't give an alibi. The important point is he doesn't say, oh, I was at a concert or whatever, somewhere in Kingston. No alibi. Campbell, in his unsworn statement, accepted that he drove, he says, ahead of the deceased and Chow in another car to the premises, but he says the deceased got out before getting to those premises. And when Campbell got to the premises in question, he says he left Chow there. In other words, Chow did go there, but Campbell says he then left. And later, he saw that Chow, later that evening, he said the only thing Chow mentioned was that Palmer had received a dog bite and had to be taken to hospital. That's 4383 to 4386. Jones's defense was a very short statement. He just said the police were lying about him. That's 6137, that's 16, at 16, or that's the, I think, of the SFI, and in the record, 4387 to 8. And St. John said he left the premises just as Chow entered, and he saw Palmer getting bitten by a dog. And that's 4390 to 4392. But the short point is that there was no denial, as far as one could take out, that they were there. And that is significant because the premises are then subsequently destroyed a few days later, or partly destroyed. And there's no explanation for this. Now, as to the exhibits, X14C, Exhibit 14C and JS2, their cases were simply this. The police have fabricated them. There's just a giant conspiracy to fabricate a whole mass of evidence. And there were challenges to the chain of integrity that went to that. That was it. But there was no explanation as to why the police should have done any of this at all. Now, my lords, bearing all that in mind, we say this was an overwhelming case where, for some reason, the only real question was, were the police in some way motivated, or did they fabricate all this evidence? That was it. That was the question for the jury. And my lords, my lady, I respectfully submit there was nothing to support that. Difficult to see, therefore, in those circumstances, why the alleged, or rather what you might call the bribery, would have made any difference to the consideration of their verdict. And I do submit the strength of a prosecution case in circumstances like this is a material factor. When one was asking, the question is there a risk, a real risk, that the verdict was influenced by prejudice? And I say, no, there's no real risk of that. My lords, my ladies, as far as the jury retirement point is concerned, that's what we say. So we say there was a fair trial. And the fundamental point is you can be satisfied that that 10-1 verdict was a verdict given by the jurors, or the 10, in accordance with their oath, uninfluenced by bias or prejudice. And if that's right, I submit the appeal must be dismissed. The next question I can deal with very briefly is the jury retirement point. my lords, my lady, I submit the following very short points. At the time, that's in 2011, there was no established practice written in a bench book or anything like that. The matter was left to the judge's judgment as to when to send the jury out. Second, I am informed by the Director of Public Prosecutions, who was here, who will provide more detail on the point. In real life, juries never take more than about a couple of hours or so to come up with their verdicts, even after long trials. And it is unheard of for them ever to have to be sequestered in a hotel room overnight. It just doesn't happen. Thirdly, there was, in my submission, no pressure applied by the judge in his directions. This is not a case where there was something the judge said at some point which suggested to the jury, you better get on with it. Far from it. There's at no point anything which the judge says to the effect, I do want you to come back in an hour or so, or please make your minds up, and so forth. So, nothing at all. No criticism of what the judge actually says. And finally, and I submit importantly, the Court of Appeal, who know all about this, how the system works, saw nothing wrong in what had happened. And if I can give you the reference, it's E5854, paragraphs 203 to 205, where they describe, where they go through some of the cases about sending juries out in different jurisdictions, and then again at 209, where they come up with 5854, paragraphs 203 to 205, where they discuss the background and various other cases, and 209. And they discuss one or two Privy Council cases where juries have been sent out actually rather later, but although the Privy Council disapproved of that, nonetheless the convictions were upheld. But in my submission, the Court of Appeal was perfectly entitled to come up with the conclusion they did. No error of law has been identified in anything the Court of Appeal said, and I submit that it's not right. It's not the board's place to interfere with the Court of Appeal's judgment on these matters. Very briefly, the proviso, in one sense, my point on the proviso is this. Even if, let us say, the judge's directions after the jury incident were not as strong as they could have been or should have been, or even if the retirement was too late in the day, there is still no reason to suspect that the jury was infected by bias or the risk of bias, given all the matters I have said. That being so, even if there was some irregularity or some imperfection in the way the trial was conducted, this is a case where there has been no, to use the words of the statute, no substantial miscarriage of justice. I should emphasize that I accept that if there was a risk of bias, a real risk of bias in the verdict, that would mean the trial was unfair, and that would also mean that you couldn't apply the proviso. An unfair trial is written water. But if the trial was fair, in my submission, you apply the proviso.
Do we have the statutory provision that contains the proviso?
I think we do.
Yeah.
In the bundle. For some reason, I seem to remember reading it recently. If I'm wrong, I'll be corrected. Perhaps I can.
Perhaps you could have the reference later.
I'll give you the references if I can.
Thank you very much.
My lord, my lords, my lady, that is only one point.
Yes, I think it's page 6806.
Thank you.
I think it's in the standard form of wording you're probably familiar with from other
Well,
jurisdictions.
I perhaps noticed that they vary on
Oh,
Well, the one we've been given
That's why I asked.
is the Judicature Appellate Jurisdiction Act, and it's section 14, the proviso to section 14.1.
Thank you.
no substantial miscarriage of justice test.
Yes.
And that's why I say there is, subject to the unfair trial point, subject to the unfair trial point. There's no unfair trial. The proviso I submit applies. The final question is that of remission. In my submission, this would hardly be a more serious case. It is of particular concern that we are talking here about great celebrities. That doesn't mean you apply a different standard. But of course, it does mean, in my respectful submission, such a high-profile case with, on the face of it, such overwhelming evidence. Most of it, of course, not the entirety of it, being of a technical nature and so forth. I submit this would be an appropriate case for the matter to be remitted for a retrial. My lords, I don't think on the whole you yourselves do that. You normally send it back to the Court of Appeal to consider. But I would submit there's every reason, if I'm wrong, for the Court of Appeal to consider what to do. My lords, those are my submissions on the main point. I've only got a little bit of time on the other points. I think I'm right to say my lords, you have seen our written case.
Yeah, this is the JS2.
Yes, the JS2 point.
Want to hear about it? Or do you want to go off the bench to discuss it?
Should we write this for a minute?
Yes. Mr. Knox, we'll rise for a moment or two just to consider whether we need to hear you on the JS2 point.
I'm obliged.
We don't require to hear you on the JS2 issue, Mr. Knox.
Obliged, my lord.
Thank you very much. Yes, Mr. Southey.
My lords and my lady. Can I deal with my learned friend's submissions, not in the order in which he made them, but hopefully by topic, because that may assist, I hope. At the heart, obviously, of my learned friend's submissions was a submission, essentially, that the way in which the court should look at this was in two stages, the jury issue. The first being, was the judge obliged to discharge one juror, and the second being, was the judge then obliged to discharge others because of the potential impact of that one juror. Our submission is that that approach is flawed, and we make that submission for two reasons, two independent reasons. The first is this: my learned friend said, albeit slightly half-heartedly, one might think, when asked a question, that the test essentially that should be applied is not the Porter and McGill-Lowell test. It was one, I think he referred to it ultimately as being possible bias, not appearance of bias. In other words, as I understood it, actual bias, not apparent bias. In our submission, that was an important submission for him to make, and he needed to make that for two reasons. Firstly, because he accepts that ultimately this jury included, to use his language, a bent juror. In terms of the fair-minded bystander, that immediately must raise eyebrows. But secondly, probably more importantly in one sense, his submissions this morning focused on what whether or not the judge was acting reasonably. That in our submission is not ultimately the key question. The key question is whether or not the fair-minded bystander would effectively conclude there was a real risk of bias. Now, the fair-minded bystander test has been consistently, I'll just give you the references to it, applied by criminal courts. It was applied in Brown, as you saw when I opened, which is at page 6330, paragraph 38. It was also applied, applying Brown in Morrison, which my learned friend took you to, page 7564, paragraph 36. And there's good reason for it to apply. There's no suggestion anywhere that in any case law that there's a different test, but the good reason for it, and it links in with the submissions I made yesterday about Lowell. You'll remember in Lowell, which is 6318, the court emphasized essentially that the reason for the fair-minded bystander test was the need to ensure that there was confidence in the justice system in a democratic society. The language used, if I remember right, is public perception is key. And that need for public perception, it must apply equally as powerfully in crime, if not more powerfully, where liberty is at issue, confidence in the jury system is important. That was part of Lord Justice Bingham's, as he was then, remarks in Putnam. And so public confidence remains as important. And it should be noted, again, I won't take you to it given time, but in Gregory in the United Kingdom, consistent with what I've just said, a criminal case, 7930, the European Court of Human Rights started by directing themselves that courts must inspire confidence, same principle as Lowell, paragraph 43, and referred to the need for there to be impartiality subjectively as well as objectively. In other words, it must appear, a criminal court must appear unbiased. And there is nothing in our submission that supports a departure from Porter and McGill. One thing I should say, just because there was some suggestion about what was argued in the Court of Appeal, paragraph 240 of the Court of Appeal's judgment expressly refers to an argument that Porter and McGill applied. It was said that the judge had applied the wrong test. That's electronic bundle 5870. That is preceded, just in terms of what's argued, at reference page 5867 to 68. paragraph 234 by reference to the fact there was an argument about overcompensation. So overcompensation clearly was before the Court of Appeal.
What was the paragraph reference for that?
234.
234, thank you.
Second point, whether or not I'm right about the first point, in our submission, the prosecution's approach is essentially of saying you can have a jury with one biased member and it's still a lawful jury is inconsistent with the statutory scheme. And there are a couple of features that I'll just remind you of. Firstly, if you go to, and these are 6803 or the new version of the Jury Act is in same terms essentially for these purposes. 31.3, you will remember, is the provision that talks about how a jury is properly constituted if it's not reduced by more than one. But if you are discounting someone essentially on the basis that they no longer should properly be a member of the jury because they are bent, again to use that language, in those circumstances, the jury ceases, we would submit, to be properly constituted. Now, one particular reason for that is that if you look at 31.4,
it might be helpful for us to have this in front of us in the correct version, which was sent by email to us earlier this morning.
I'm sorry, I've got it. That's why I've got the iPad up, so I've got the correct version. So
Yeah.
I don't think the language changes for these purposes, but I absolutely accept the point that it's better to have the source.
What time was it sent? My email was crashed.
Oh, I see.
Added to SharePoint.
It was,
It's on SharePoint.
I'm disconnected. I'm disconnected. Yeah, I'm disconnected. I'm not getting any emails.
Yeah, I got it.
I think within the internal pagination, it's page 18.
Yes,
I think 4 of us have the
Sorry,
Latest version.
my email is disconnected.
I'm sorry.
It should be on SharePoint as well.
No, this version came in. This has not appeared on mine, probably for the same reason.
You would have to manage.
I'll manage, yeah.
Yes, Lord Lloyd Jones will manage with the
Thank you.
2016 version.
Thank you. 31.3 is the provision essentially that talks about a properly constituted jury and makes it clear that if the numbers are not reduced by more than one, the jury remains properly constituted. Well, we would submit that if someone is biased and essentially being discounted by the judge as on the basis that essentially the verdict can be delivered by 10, that is inconsistent with 31.3. But 31.4, even more importantly, in one sense, deals with what a verdict of 11 jurors, a verdict of 11 jurors is treated. It provides that it will be unanimous, essentially deemed as unanimous, even though one person has been discharged, demonstrating really that the expectation of the legislation is that all jurors will participate. And that's even clearer, we would submit. If you go down in the version that we've got it's page 24 within the pagination of the document, section 44(1)(a), which is the provision that allowed a majority verdict. And of course, that provides, as the court's well aware, and as is common, that you can't immediately go to a jury verdict. And that's important because what it's demonstrating is that the starting point should be that all jurors participate in the verdict and all jurors should, as far as possible, be in agreement about the verdict. If that's not possible, then you can go to a majority verdict. But the view is that everyone should participate. All of that explains in our submission why, and none of this is sort of unusual or it's reflected broadly in similar provisions or similar approaches in England and Wales. All of that explains why in Putnam, you will remember, and it's page 7579.
Sorry, yeah.
Sorry.
Can I just check? Are you able to help us on whether the murder is or the murder falling within section 44(1)(a)?
Is capital.
No, it wasn't, and that's why when I used 44(1)(a), I meant capital A, not little a, because that's why the majority verdict could be reached, as obviously it eventually was. But as I say, the key point we make about that is that demonstrates the idea that the jury should, as far as possible, be coming to a collective decision. And that all explains. You'll remember, if you go back to Lord Bingham at Lord Justice Bingham, as he then was, at 7579, the passage towards the bottom of the page that I took you to yesterday, Lord Bingham bases his approach in circumstances where, on the material they had, essentially, it was one juror who was approached. He bases his approach on the need for collective and individual integrity. He's making it clear, and we would submit this is consistent with the statutory scheme. The jury system isn't a system where you can say, well, you've got 11 individual actors. He's saying you've got 11 people who have individual responsibilities, but they also act as a collective. And that's what the legislation is plainly intended to represent. And that is reflected, I won't take you back to it, in the Bechandan decision that we produced yesterday from the Guyana Court of Appeal. It explains why a trial without its full numbers can't be regarded as a valid trial, even though in principle it might have been possible to proceed with the number that was who were actually involved in the verdict. And fundamentally, there is a good reason for that, and it's this. Everyone remembers, most lawyers remember very strongly 12 Angry Men. And it's the point about that is you can have one member of the jury who is completely out of line with everybody else, who persuades everybody. And your right is to have that one person come forward. And one of the real risks in these circumstances is that the corrupt juror, my learned friend, because he needs this, has to accept that the corrupt juror can participate. It's potentially important he participates because he might be the minority, the person who is going to try and persuade everybody else that he's right on the evidence. But of course, there is then a problem because all the other jurors, if they're aware of this, may well, understandably, want to discount his views perfectly properly in one sense, you would think. But that's the fundamental problem that you've got in this case. And that's one of the reasons why you can't separate this, because you can't separate the questions in the way that my learned friend does, because he needs to say, because he needs the corrupt juror to remain on the jury, that corrupt juror needs to be able to participate in principle in the decision making, but it's very difficult to see how they can do that without then there being a problem. And all of that statutory scheme obviously needs to be viewed in light of the fact that there is a right under the Charter, Section 16, to an independent and impartial tribunal. And my learned friend took you to the structure of the Jury Act. He made a number of points. His basic point was essentially that although if you had an incapable juror, for example, someone suffering from mental disorder, they would have to be discharged. But in some sense, a biased juror was different. But the fundamental problem is, with that submission, That the biased juror, of course, is incapable of complying with their oath by definition. If they are biased, the oath, in this sort of situation, in any event, the corrupt juror has already said that they're not going to comply with their oath. Why are they any different to others who are effectively discharged because they're unable to comply with their oath? Now, my learned friend, in submissions, essentially argued that one of the reasons why the judge wasn't obliged to discharge the briber was that they apparently favoured the defendant. And he emphasised the fact that the forewoman had given evidence, or had given an account that nobody was listening to the person offering bribes. I think the reference is electronic bundle 517221. But that demonstrates in one sense the problem, because it demonstrates how once you've got to this situation, you're not adopting, the jury wasn't adopting the Putnam approach. It wasn't taking collective responsibility, essentially. It was saying, you need to be isolated. In terms of the impact on the jury, what my learned friend failed to address in my submission is how the judge was actually in a realistic position to address and understand the impact on the jury. He had no evidence about how long the jurors had been aware of this, the Putnam point that the longer you're aware of it, the more embedded prejudice can become. He had no explanation as to why the jurors hadn't drawn attention to it. The jurors were not asked individually if they could put the bribe to one side. And so on the face of it, he had very little information about impact. And that meant it was very difficult, we would submit, for him to assess. Now, his sort of fundamental point about considering the impact is that what the judge was entitled to take account of, or what justifies the approach of the judge, was that discharging the whole jury would have brought the system into disrepute. It would fundamentally undermine the jury system. Firstly, there's no indication these circumstances are common, but if there is a problem along those lines, the answer is for the legislature to introduce legislation such as England. If the system becomes undermined, essentially, there are solutions. The solution isn't to allow a trial to continue in circumstances where there is a lack of independence. That was the context, though, of my learned friend's submissions, which fundamentally were that the judge's discretion was exercised correctly in not discharging the jury.
I take it there's no evidence about jury tampering in Jamaica that's before us?
No.
Thank you.
Not that, certainly not that I'm aware of. My learned friend's next submission, based on what I've just said, was that the judge exercised his discretion correctly. It was an exercise of his discretion. Firstly, given what I've already said about the Porter and McGill test, the Lawal test, in our submission, that's the wrong question. The real question here is, was the constitutional right to an independent trial by an independent court breached? That's important because the suggestion was essentially all that the judge had was a mere allegation. Firstly, we of course know that there was in fact a conviction, but secondly, in any event, the issue is real risk. The learned friend said the judge was entitled to rely on the forewoman's role, and in particular the fact that she said that none of the other jurors had taken a bribe and that they would follow their oath. Part of the problem with that, the primary problem with that, of course, is where you have unconscious bias, by definition, it is a problem the individual may find difficult to discount, whatever their sort of professed approach will be to decision making. That's why, if you think about Putnam in my submission, Lord Justice Bingham made it clear there comes a point where you have to discharge the jury if, for example, the poison has been allowed to spread for too long. The second point is, of course, that was all information obtained through the forewoman, and that is a problem because of the lack of any public record of what the jurors themselves said, and I'll potentially come back to that. The third point my learned friend made was that the Court of Appeal upheld the conviction. Unsurprisingly, we would say that the approach of the Court of Appeal, particularly paragraph 238, and I won't take you to it, everyone's familiar with it, obviously demonstrated a flawed approach. Some further points that my learned friend made to justify essentially the outcome in this case. The first was that the bribe was offered by someone who was seeking to favour the defendant. In submissions, unlike in writing, it appeared to be accepted that there's no evidence that any of the defendants was to blame for the bribe. That's important because it means none of them have taken actions which could in any sense be said to be effectively a waiver of their rights. But more importantly, Putnam is clear authority, and it's 7579, that there is a risk of prejudice against, and that's obvious. People do overcompensate. My learned friend said, you can tell that the jury is independent because it acquitted Mr. Williams. Already made the point, effectively, that we would submit that the jury simply couldn't lawfully deliver a verdict. But in any event, bias doesn't necessarily mean that someone will always deliver a verdict that is the verdict sought by the party they favour. Bias means essentially you're more likely to favour one party than the other. The fact that the evidence, put it this way, you can have a case where a biased individual acts against their biases because the evidence is so overwhelming. That doesn't mean they weren't biased. It doesn't mean that there isn't a higher threshold to overcome if the bias is against you. Bias simply means you favour one party over the other. I mean, that's in our submission fundamental. And that's why the acquittal of Mr. Williams, in circumstances where the evidence against Mr. Williams appears to have been particularly weak, dependent on Mr. Chow alone, doesn't necessarily mean that there wasn't, that the jury didn't favour the prosecution in light of what had happened, unconsciously favoured the prosecution. Now, my learned friend, in terms of jury independence and the relevance of Mr. Williams' acquittal, initially cited Gregory. Gregory, in fact, was the one where it was the case where the European Court found no violation of Article 6 in light of directions. Gregory, though, was followed by Sander, which my learned friend, I think, this morning accepted was the case where one person had been acquitted. The approach of the majority of the European Court was to find, and you see this, I think it's 7956, paragraph 30, was to find a violation of Article 6 because a racist juror can't be expected to change their views in response to a direction. Now that is, we would submit, consistent with Putnam recognizing that there comes a point essentially at which prejudicial views become so embedded that you can't change your mind. My learned friend pointed to the dissenting judgment in Sander, but that's a dissenting judgment. The majority approach in our submission is the correct one, as I say, reflecting Putnam, and that demonstrates the real problem in relation to the second aspect of my learned friend's case, which is the impact on the other jurors, which is the judge simply didn't have the information to know whether or not this was a poison that could realistically be discounted on the basis of a direction. My learned friend also said you can discount unconscious bias because of the strength of the evidence. The jurors will essentially have said that they didn't need to consider the corruption because the case was so strong. The fundamental problem we would submit with that, ignoring some practical problems I'll come to in a moment, is that what that is doing is inviting the court to speculate about the jury's thinking. It doesn't know how the jury approached the decision making. By definition, the jurors may not know what factors, or every factor that influenced them. We are potentially talking here about unconscious bias, and that is obviously something that the jury won't necessarily be aware of. And it's particularly difficult for the court to understand effectively the impact of bias when it simply didn't sit through this long trial. And then, friend summarised the evidence. Just pick up a couple of points out of that, and a sort of fundamental point that's at the heart of this. He started by referring to Mr. Chow's evidence, but Mr. Chow's evidence was clearly rejected in part by the jury because Mr. Williams was acquitted. He then relied on the electronic exhibits, but as he accepts fairly, there were arguments about the integrity of those exhibits. That's a credibility issue. He finally says, the heart of the defence case was that various exhibits had been fabricated. That is a credibility issue. That's an issue that requires assessment of what the officers and others said in cross-examination. And we would submit it's impossible for this court, many years after the event, with transcripts, but not much else, essentially, to assess the extent to which the jury would inevitably have discounted, because of the strength of the evidence, prejudicial material. In any event, fundamentally, that explains why there is a right to trial by an independent jury, because it's for the jury to assess facts. What my learned friends' submissions do is potentially undermine that right. And that explains why all the authorities demonstrate essentially that the proviso doesn't apply. What my learned friend was seeking to do in my submission was seeking to apply the proviso, having accepted later in his submissions that the proviso can't apply to an unfair trial. Well, if it's a biased jury, you have an unfair trial. And that's entirely consistent with Serafin as well, because it clearly, if the jury was unlawful because it was biased or indeed didn't comply with the Jury Act, Serafin paragraph 49 in our submission makes it clear the verdict can't be upheld. In terms of directions, Bonnet-Taylor in our submission reflects the approach in Smith that directions must be apposite, clear and emphatic. The reference to Smith I gave in opening, it's 7671 paragraph 24. The direction in Bonnet-Taylor that was upheld at 629024 was a specific direction.
Sorry, 6290.
6290 paragraph 24.
Thank you.
And that's the context of what followed, which was the assumption that the jury would follow the direction. It's important to note, however, that paragraph 25, the statement that there is an assumption that the jury will follow a direction, was then followed by paragraph 26, which started with the word however, making it clear there was a degree of qualification, that emphasized the importance of the protocol, the need to investigate, because you can't, in one sense, rely on a direction until you're satisfied that the matter is capable of being cured. Here, the problem with the directions were, firstly, they were to a juror who'd already demonstrated they would not comply with the oath. Secondly, those directions were given in the context of what was, by our calculations, a 5-day summing up, where there had been repeated references to the need to comply with the oath. And that, in one sense, means this just looked like a repeat of those directions. And those directions had been given in the circumstances where it would have been clear to the jury that the judge was concerned that they might be influenced by the fame of at least one of the defendants. And so the focus of those directions was, be cautious, you'll read a lot about this trial, essentially, but you'll be, and so there was essentially another direction, didn't expressly reference fame, but it was in the context of a situation where the judge was clearly expressing concerns about the impact of fame. In any event, as I say, we would say you can't give a direction that in circumstances where there is a risk of unconscious bias. It's very difficult to direct the jury in a way that will overcome that, if it's sufficiently embedded at least.
Why are we assuming it's unconscious bias? If every member of the jury has been approached and offered a bribe to acquit the defendant, someone would think it was a quite conscious bias.
Well,
the jury would think, but the law does not think, that would be a relevant matter going to their guilt or innocence. But of course, their job is to decide it in accordance with the evidence. Isn't the real problem here that it would be a temptation hard to resist to decide or to be influenced in the decision of the case by something other than the evidence presented to the court?
Well, to be clear, I'm not saying it wasn't conscious bias. What I'm dealing with, what I'm dealing with is, in one sense, my learned friend's submission, which is to say, you can trust the jury to comply with a direction that they should, I mean, there is a problem with how detailed the direction was, but let's assume that the direction was sufficiently detailed. You can trust the jury to comply with a direction that they should disregard this factor. I mean, there's no reason in practice why it couldn't have said, because the jury were all meant to be aware of the bribe. I'm aware some of you have been approached about a bribe. You should. Now, the prosecution submission is, you can trust the jury to comply with that. Whether that's realistic as a matter of human nature may be open to question. But assuming that's right, you still have the problem that even if a juror says to themselves, I understand that this looks pretty bad, that there was a bribe offered to us, but I understand what the judge has said. I need to put that out of my mind. It is very difficult, and this is why I focused on the unconscious bias aspect. It's very difficult as a matter of human nature to actually stop yourself unconsciously being influenced by that, because that's the way unconscious bias works. And that's why. It's because I'm in one sense focusing on a particular difficulty that in our submission simply can't be addressed by a direction. But I accept that in reality, conscious bias is a very real problem here. Yes, can I am in terms of just a couple of final features. Firstly, the procedure adopted. All we would invite the court to look at is, because my learned friend relies on it very heavily, Braithwaite 7358, the importance, in particular the citation at para 52 of an earlier case called Ball, the importance of matters being properly recorded in open court, which is the problem with the use of the forewoman, for example. That is important because it allows essentially assurance that there's been compliance with the correct approach.
There was a recording. It was transcribed.
But there was that, but not of the forewoman's communications with the jury. And so in Braithwaite, there was a lot of material that had been transcribed, but the problem was that there was a sort of private communication between judge and jury that there was material that hadn't adequately been recorded. In terms of the retirement, very quickly, the bench book is clearly consolidating. The fact of the court, the approach of the Court of Appeal demonstrates they clearly believe that the judge wanted to and was entitled to try and get a verdict quickly, essentially, because of the problems that had arisen. That is a reflection we would submit of pressure being put on the jury. Finally, in terms of, I think retrial proviso I've probably already addressed, given my learned friend submissions. In our submission, it's pretty clear the proviso can't apply. Retrial, one thing I'd wish to highlight about that, my learned friend's submissions yesterday about why the judge was entitled to adopt the approach he did, correctly and fairly pointed to the potential difficulties of a retrial in light of matters such as profile. Well, those difficulties are not diminished. They've become greater because of passage of time. This is something that's now high profile. In our submission, that submission supports our argument that there's no point remitting this because a fair trial is now very difficult, impossible, we would submit. Anything else? Thank you. I think that covers it. I just one.
But the Morrison pointed that
That's right. Thank you. Thank you.
Well, we're most grateful to all counsel who addressed us and also to the people sitting behind who have no doubt contributed to what we've heard. We're very grateful. We'll now consider what's been said and consider what advice we shall humbly tender to His Majesty. The court will adjourn.